Let's proceed then.
Morning, Your Honor. My name is Michael Hausman, Code Enforcement Manager for the town of Fort Myers Beach. We have some amendments to the agenda. I'd like to start with housekeeping, if you're okay with that.
All right, let's go ahead and, is everybody here that needs to be here to get started?
Yes, if you want to swear everybody in, that would be great as well.
Yeah, why don't we go ahead and take care of some of the preliminaries. Good morning to everyone. This is the Fort Myers Beach Special Magistrate hearings scheduled for December 4, 2025, 9 a.m., getting underway as scheduled. My name is John Van Lanningham, and I am the Fort Myers Beach Special Magistrate presiding today, and we are conducting the hearings by a Zoom teleconference. I know we have a couple of preliminary items we can take care of fairly quickly here, I think. We have the minutes from the October 29, 2025 meeting for approval. Are there any objections to that, the approval of those minutes?
No, Your Honor.
So without objection, we will approve those. And Mr. Hausman, you were about to tell me about some changes to the agenda?
Yes, first item on the agenda under status updates was a postponement from last month, case 2025-0809. That came into compliance since the last hearing and will not be heard before you today.
Okay, very good.
And then under violation cases, item C, 2025-0891 is now in compliance and will not be heard today.
Good. Any other changes?
No, that's it, Your Honor.
All right, good. All right, we can go ahead then, and we have two violation cases here on the agenda. We can go ahead and call those.
Agenda item A, case number 2025-1060. It is 151 Miramar Street. Property owners Carol, Jean, and Danny Lewis Thomas. Property address 151 Miramar Street. Again, good afternoon, Your Honor. My name is Michael Hausman. I'm the code manager for Town of Fort Myers Beach Code Compliance. I supervise the day-to-day operations of Town of Fort Myers Beach Code and Compliance Department and supervise 3 code enforcement officers. First case for your review today is 2025-1060, 151 Miramar Street. For inclusion in the record, Exhibit A, as presented to the magistrate, contains notice of violation and notice of hearing, affidavit of service, proof of mailing, and proof of ownership. We'd like to submit that into evidence.
Go ahead and receive that evidence at this time.
Initial inspection was conducted on October 15, 2025. The notice of violation, notice of hearing was issued on October 20th, 2025, with a compliance deadline of November 17th, 2025, with a hearing date of today at 9 a.m. The notice of violation, notice of hearing was posted at 151 Miramar Street and Town Hall on October 20th, 2025, and sent certified mail and regular mail on the same date to the property appraiser's mailing address of 220-675 565th Avenue, Austin, Maryland, 55912, and sent regular mail to the violation address. Violation before you today is keeping or maintaining a non-compliant portion of the structure, more specifically a sink and plumbing on the ground floor of the property in violation of the code and FEMA regulations. Exhibit B, which was also sent to you, contains an affidavit of noncompliance dated November 25th, 2025, including a permit review on that date. And I reviewed the records again this morning, did not show any records submitted to remove that plumbing. Recommendation would be give the respondent 30 days which to comply, or a fine of $250 a day thereafter, and assess administrative costs in the amount of $250. The property owner is here today and would like to.
They are ready to be sworn in, Your Honor.
All right, very good. And who do I have here for the, do I have Go ahead, Peter. Who's at the podium?
You can state
this
your
is-
name.
Hi.
Good morning.
May it please the court, my name is Carol Thomas, and I'm here with my husband Dan in opposition to the administrative enforcement initiated by the town of Fort Myers Beach, aiming or
Ms.
hope.
Thomas? Yeah, let me just interrupt you here for a moment. Let me get you sworn in. If you're going to give testimony, would you raise your right hand for me, please? You swear or affirm the testimony you'll give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, very good. And did you have any questions for Officer Hausman?
No, I do not at this time.
No?
I do not have any questions at this time.
All right, you may proceed then.
Okay. My husband and I are here in opposition to the administrative enforcement initiated by the town of Fort Myers Beach, aiming or hoping to force us to demolish our lower level plumbing, which has been in place and recognized since 1971. I have previously, on November 17th, provided 4 packets of information to the court and council with our exhibit list containing 11 separate exhibits. Also provided are photos taken prior to our purchase in April of 2021 that the Crumbies allowed us to take for them before we purchased. Your Honor, do you have a copy of our exhibits?
I don't at the moment. I'm checking to see if I have them here. Give me one second.
They were delivered on November 17th. 4 packets of information were given to the city on November 17th.
Your Honor, I just transmitted some files to you this morning.
Okay. Give me one moment then, Mr. Thomas. Just trying to open this file here. Give me one second. Okay. All right. Just give me a moment to download these.
Sure.
All right, I've got them here.
Pardon me?
I have them now.
Okay. All right. I would also like today to add Exhibit 12 to the documentation. It contains specific pages from permit number RES 2007-10191. I have 3 copies available for the court. If they would like to have those, I did submit 1 copy this morning I gave you to have submitted to the judge, but if Michael would like a personal copy, I have that in my hand here.
This is
Pardon
the-
me?
There is an Exhibit 12 in the packet I was sent. It says portion of permit appraisal report. Is that what you're referring to?
Yes, Exhibit 12 says portion of permit/appraisal report.
I do have that.
You do have that?
I do.
Okay, thank you. I also have a copy of the entire permit. It is a 75-page document, and I would happily lend it to the court for them to copy.
What's the permit for?
The permit is referenced a few times, and so I printed the entire permit. It's 75 pages. I decided not to make multiple copies because of
What's it a permit for?
the permit is for the permit that was initiated in 2007 by the Crumby family.
They're the prior owners?
Correct, one of the prior owners.
You purchased from them, or?
We did purchase from them, yes.
What year did you buy the property?
We bought the property in 2021, April 30th. The photos that I submitted are from March of 2021.
Go ahead. You may
Okay.
proceed.
Okay, so I'd like to ask the court to recognize that our house was built in 1971, making it a pre-firm house. At this point, I will initiate our testimony in response to the allegations of the city.
Why don't you go ahead and do that?
Okay. I'd like to direct the court's attention to Exhibit 1, which is the affidavit of Constance O. Harvey, who is a former resident of Fort Myers Beach at 81 Miramar. Her family has been on Miramar Street or owned that property for over 85 years. She can attest to the fact that her house had a finished lower level going back well before 1984, and I offer Exhibit 1, which is her letter, which has been notarized. Her statement.
This is a statement of a neighbor. Ms. Harvey's a neighbor. Is that what you're saying?
She lived at one point down the street at 81 Miramar. She no longer resides in Florida. I did extensive research finding property owners to see if somebody had information in regards to our property. She was one of the people that I was able to contact and was willing to provide a statement because she had knowledge of what our home was. Part of her letter even says that there were fewer homes. There were fewer homes then. The population on the island was between 27 and 3,500 people. The island had about 1,100 homes in total. It was a much smaller footprint back then, making it easier for me to have recall, especially when asked about homes on Miramar. Our family watched many of the houses be placed on the street. Most of them came from streets and avenues from already on the island. So that's just a part of her statement.
All right. Well, I'll receive it. I mean, it's hearsay because this witness isn't here to testify, so it may have limited value. To the extent it might corroborate or supplement your testimony, I can look at it for those purposes, kind of limited purposes. But I assume you're going to testify about the condition of the property when you purchased it?
Pardon me? I'm sorry?
I assume you're going to testify, about the condition of
Yes.
the property when you purchased it.
Yes, I will get to that.
All right,
Okay.
go ahead.
So then I would offer Exhibit number 2, which is a notarized letter from Rebecca Crott, who lived at 120 Miramar Street. She indicates that her family has owned that property and still owns it currently since 1976. And she also has living, working knowledge of the house having a finished lower level since the 1970s. Exhibit number 3 is an affidavit from Patty Smith. I would like to direct the court's attention to Exhibit 3. Ms. Smith is now a resident of New Jersey. She can attest to her family owning the property at 81 Miramar Street since the 1930s. She indicated she cannot remember a time that the lower level of 151 Miramar was not finished, and she has been visiting Miramar Street since the 1960s. She indicated that while she cannot remember the exact date, she can attest to the fact that she used the bathroom at the lower level of 151 Miramar in 1980 while her family's cottage was being raised and plumbing was being added to their ground floor. At this time, I would like to direct the court's attention to the Exhibit number 4, which is the affidavit of Helen Crumby. The affidavit of Mrs. Crumby is currently a resident of Fort Myers. She and her husband Jim sold the property at 151 Miramar to my husband and I. Mrs. Crumby and her husband purchased this property in May of 1998, and the lower level was finished at that time. They purchased the property from Robert and Betty Carr, who at the time had a retired postal worker renting the lower level as an efficiency apartment. Crumby's added an additional floor to our home in 2008, which included a bedroom and bathroom, and also replacing the patio door on our lower level, all of which was outlined in the permit, which was issued, inspected, and passed by all authorities. We offer Exhibit number 4.
All right, as with the other affidavits, I'll receive them again. They are hearsay, so.
Mr. and Mrs.
Yeah,
Crumby
no
are
value,
here. Mr. and Mrs. Crumby are here as witnesses for me.
Okay.
Would you like to speak with them now, Your Honor?
Why don't you finish your testimony, and then we'll, if
Okay.
you want to call them, you can do that.
Okay. I would now like to direct the court's attention to Exhibit number 5. Exhibit number 5 is the 2007 Lee County Property Data Detail. Exhibit number 5 was taken from Lee County website, the photo of which shows the finished lower level. On page 2 of exhibit number 5, you can see that their data shows, midway down the page, their data shows that we had a finished lower level that was heated and air conditioned under air, where it says heated / under air, and it says base 528 yes, base 288 yes, finished lower level, and the carport and patio and scope of work is there. It is also on the third page, shows the county's drawing of the finished lower level. I offer exhibit number 5.
I'll receive that evidence.
Thank you. I would now like to address the court's attention to exhibit number 6, which is the Crumbies permit application number RES 2007-10191. That was submitted by Woodland Custom Homes. That clearly shows the living area, bedroom, bathroom, and utility room. On the very first, one of the pages of this document, you can see that it is at the very top. It is dated January 8th of 2008 at 11:08 a.m. And Judy Starnes, Starnes, took this document and this picture into record. And I've provided some other pictures that were a part of that 75-page permit. We would offer exhibit 6 at this time.
All right, I'll receive that evidence.
Okay. Exhibit number 7. I would like to direct the courts to exhibit number 7, which includes a 2024 permit revision to permit number 232518, which was adding the lower level to the scope of work, like for like. As you can see, the original floor plan shows the bedroom, kitchenette, bathroom, and owner's closet. Plumbing was not added, removed, or changed. We made necessary repairs where needed at the site of the original plumbing.
What sort of repairs?
Excuse me?
What sort of repairs were made?
Repairs meaning after Hurricane Ian, for instance, the bathtub was damaged quite a bit, so we removed the bathtub and just put in a stand-up shower. We didn't change any of the plumbing. The toilet was cracked, so we replaced the toilet. We obviously cleaned, and then the kitchen sink and the bathroom sink are exactly where they were, but they both had wooden cabinets underneath them, and we removed those things and replaced them with freestanding sinks. And if the court would like, I'm sure I can find pictures on my phone of what the sinks in the bathroom look like.
Okay, this was work that you did in 2024?
The 2022 was what we did after Ian. That
Okay,
permit
so-
was from 2022 after Hurricane Ian.
All right, got it.
Okay? Okay? All right, now
Yeah.
I would like to draw the court's attention to exhibit number 8, which is the completion certificate 202-50721 for permit number 232518, which in the activities section says Realtor.com shows layout which includes bedroom and kitchenette. These plans were approved in revision and permit has been finalized. In addition, under the site inspection on that same page from July 11th, 2025, the permit indicated to add the lower level repair like for like. We would offer exhibit number 8 into evidence.
All right, I'll receive that in evidence.
Pardon me?
I'll receive it.
Thank you. Would now like to draw the court's attention to exhibit number 9, which is the Lee County property card. This was taken off of the Lee County Property Appraiser's website, which on page 1 indicates under the building sub-area details, and I have it highlighted on my page if you're not familiar with where that is. And it says base 1971, tells exactly what it was, finished lower level, 552 square feet, finished open porch, And as you read down, it tells you exactly everything that happened in 1971 on the first page. Second page was just a part of that, so I included it. And again, the third page of that document into evidence is the county's drawing showing a finished lower level. I would offer exhibit number 9.
All right, I'll receive that, Evan.
Okay. Exhibit number 10, I would like to address or show the photograph that was provided to us by the Crumbie family, which is a picture of the lower level when they purchased the home in 1998. This picture will come into play again when I'm further down the road in another evidence packet. So I would offer exhibit number 10 for the court. I would now like to,
Just to clarify, I guess you did not personally see the property in this condition in 1998.
no, I did not. The Crumbies are here, and they provided these photos for us.
Okay.
Okay.
Well, I'll receive it, and we may hear testimony from the Crumbies, so go ahead.
Okay. Then I would like to address the court's attention to exhibit number 11, which is again a picture that I took off of the Lee County website, this photo dates back to June of 2000, and it shows, I blew the picture up probably too far. It's a little grainy, but it absolutely shows the finished lower level. The bottom level is enclosed, and that came off of the Lee County website. I would ask for exhibit 11 to be entered into evidence.
I'll receive that in evidence.
Okay. Then the next section is probably, in your packet, is probably the photos that we submitted from when we purchased the home. Now I'll move on to exhibit number 12. I would like to present exhibit number 12, which is a portion of the 75-page permit and appraisal report from 2007. In the 2007 permit for the addition, in the appraisal report used to comply with the 50% rule, it says the house prior to remodel was a 2-bedroom, 1.5 bath. It also discussed the ground floor and apartment being grandfathered in. Both the hand and architectural drawings clearly shows the efficiency apartment with a kitchen, bath, living room, bedroom area, and laundry. The 2007 addition added a bedroom on the top floor and another bathroom. Again, the existing house had 2 bedrooms and 1.5 bathrooms prior to the addition with the ground floor efficiency apartment that contains a bathroom, kitchen, and sleeping area. Page 1 of Exhibit 12 is an enlarged portion of page 2. The highlighted area shows exactly what I am referring to. Page 3 are photos taken by the appraiser, which when examined are a close match to the photos provided by the Crumbies in Exhibit 10. And I'm not sure if, Your Honor, if you have the picture that I have in front of me, it is from the 2007 Lee County website that I went to, and it is a very grainy photo that I did try to copy for you, but it does show, if you look through there, it shows the 2 doors going into the house. One door goes into what was referred to as the owner's closet, and the second door enters into the bathroom.
I have it.
Okay, thank you. In my closing remarks, Your Honor, I am at a loss as to the objective of the city of Fort Myers Beach attempting to deny the existence of a finished lower level and plumbing, which by their own records show was present back to 1971. Since that time, there have been 2 permits for expansion or improvement, both of which acknowledge the lower level efficiency apartment, and those permits were accepted, approved, inspected, finalized, and closed. As such, we respectfully request that the court deny the request for relief from the town of Fort Myers Beach. Thank you.
All right, Ms. Thomas, before you leave the podium there, let me ask the town if it has any questions for Ms. Thomas.
Just upon review of the documents that you submitted today, and we're really reviewing the construction that happened after the hurricane, which would trigger this plumbing violation, which is what we're looking at. So it would be, we're not denying the existence that the structure is there and it was addressed in permitting as shown on your representation. It's the repair work done after the hurricane that would trigger the restriction on plumbing on the ground floor.
The plumbing existed prior to Hurricane Ian and prior to the flood mapping by FEMA in 1984. The plumbing has been there since 1971. We did not change plumbing. We did not remove plumbing. We did nothing. We would put back exactly what was there, repaired only.
Okay. Thank you.
Let me ask him, and Ms. Thomas, you have other witnesses you might want to call. I just wanted to ask Officer Hausman, again, so I'm clear, the town is focusing on the work that was done, I guess, in or around 2022?
That is correct. Any kind of repairs or substantial damage to the structure after the hurricane.
It sounds like there was at least some interior remodeling and or repair. If I understood Mr. Thomas's testimony, there was a replacement of a bathtub, for example, a toilet, maybe some cabinets and sinks or cabinets in any event. That's what the town is focusing on, that sort of interior, maybe it was mostly interior work?
That is correct, Your Honor.
In our permit revision, excuse me,
Let
I'm-
me just ask, Officer Hausman again on that point. Is the nature of the work such that any grandfathering, I know there's been testimony about some grandfathering, pre-firm, the existence of the pre-firm structure. Is the town's position that compliance would require demolishing the lower level, or is it getting it after the fact for the interior remodeling and repair work that was done, just so I can get an idea of the scope of the corrective action should a violation be found?
It would allow either a removal of the plumbing or documentation and approval of a pre-firm or non-conforming use on the ground floor. So if she could get that through our
I'm sorry, Your Honor.
floodplain manager, then that would allow that as well.
There's a separate process that the owners could pursue with regards to establishing the existence or a pre-existing, essentially establishing that it's a non-conforming lawful use?
The owner could pursue that, and I could present this evidence and any further evidence to our floodplain manager related to that.
And if that failed, when you say remove the plumbing, would that mean remove all of the plumbing or just what was put in? What would they have to do?
If it was found in violation, it requires it to be capped off or removed.
Okay, so they couldn't have any plumbing in the lower level at that point, it would, right? There would just be no plumbing there.
Under the current code, yes.
Right. Could the lower level continue to exist, or would that have to go too?
It could still be used as storage and parking, things of that nature, yes.
But not habitation, like somebody
Could be used as a habitation. There's a restriction on the plumbing on the ground floors.
Just the plumbing, okay. All right, okay.
If you wanted to, if you felt comfortable continuing this and letting the floodplain manager review the documentation, she has a copy of it as well, and bring this back to you next month, I have no problem with that. So hopefully get this taken care of. If it's allowed to be there, then we can get that documented by the floodplain manager.
I mean, that would be, if the town's agreeable to that, that might be efficient. I think the determination of whether the property is a lawful non-conforming use, a pre-firm structure that would allow this work to be done, is probably something that has to be decided through another channel, as opposed to being decided by me. If that can be done, before next month's hearing, what do you think about that, Ms. Thomas?
I guess I'm a little bit at loss as to what more the city would like me to provide as to the proof that the plumbing existed. I will do whatever the court asks of me, but I'm confused as to what the next process would be for me to further prove.
Yeah, if I'm understanding correctly, and it's probably not so much a matter of the nature of the proof. I mean, you've got a stack of documents here, you've got testimony about the condition of the property, and as I understand it, there's no dispute that there was a lower level that dates back for 4 years, as you testified. I don't think the town is disputing that. I think the question is, will the town recognize the structure as a pre-firm structure that's a lawful non-conforming use that you could do this work on without triggering, some requirements that would require you to come into compliance with current floodplain regulations, which you might not be able to meet, and would require the capping off of the plumbing. So it's maybe a matter of who the decision maker is on that. That might be a decision that's not mine to make in the first instance. Does that make sense?
It does, Your Honor.
And obviously, if the town decided that your property was, I guess, to use the vernacular, grandfathered, then it looks like to me like the path forward is much simpler. If the town decides that it's not, then we come back and I make a decision as to whether there's a violation, and if so, what the corrective action is to bring the property into compliance, which in that scenario, I think the town's position would be you've got to cap off the plumbing, which would mean no bathrooms, no sinks down in that lower level.
Which
Go ahead.
Which for me, my biggest question is, as it states in our permit, when we revised it, replacing things like for like, the permit was approved, it was inspected, it was finalized, and it was closed. They were there. They saw everything. We didn't hide anything. And
I'm not suggesting that you did. I don't hear the town to be saying that necessarily either. There's a lot of documentation here that you have provided, and obviously I haven't had a chance to read through all the records that you've provided. That's something, of course, I would do before making a final decision in the code enforcement matter.
okay.
You presented, 50 or 60 pages of documents, and while I'm listening to you, I just haven't had a chance to read them all. But it looks to me, at least on the face of it, that you've presented some permit, records and things of that nature that certainly I'll need to review. And this isn't as straightforward as some building without permit cases where, where it's just straightforward, work's been done, there's been no permit. Here you've got a permit history, you've got there's history here. Again, if you're agreeable and the town's agreeable, we could postpone the completion of this hearing until the next agenda in a month or so. And in the meantime, get an official determination from the floodplain manager at the town as to whether the property can be treated as, grandfathered, so that you might be able through that pathway to avoid the what would I think be the most serious consequence for you as the owner, the potential of having to cap off your plumbing. And I'm not saying that's necessarily going to be the decision. I don't know yet. I haven't made a decision on the enforcement case, but that's what the town is seeking. So from your standpoint, I guess it would be the worst case in the enforcement case.
That would be fine with me to appear again in a month, and I do have a full copy of the 75-page permit. If you yourself or the town would like a copy of that, I'd be happy to lend it for.
Well, why don't you bring that next time. If we hear this again in a month, you can provide a copy that can be scanned in, and I can download it. Let me go back to Officer Hausman. Is that agreeable to the town? We can continue or pass to the next agenda. In the meantime, you get the manager to review this, and depending on the outcome, maybe at the next hearing, have the floodplain manager testify about those facts.
That's agreeable to the town, and hopefully we'll get it taken care of before the next hearing.
That sounds fantastic. And if you would like to hear from the Crumbies, they are here now and as one of my witnesses.
Well, why don't we, are they potentially not available if we meet again?
Just a moment, I'll have to ask them.
And the second issue is, there may not be any disputed facts with respect to the things that they would testify about. That I take it the town's not disputing that there was a lower level or lower closure for all.
The Crumbies would be
Correct.
unavailable at the next hearing, Your Honor. Yeah.
Well, then, why don't we have them testify next time if need be, and again, maybe most of those facts are, helpful background, give me an idea of what happened, but obviously the town is focusing on 2022 and that time frame. The history makes obviously some difference because it relates to the issue of whether the property grandfather's in. And their information might be something that would be useful to the floodplain manager in reviewing that issue. But why don't we'll defer hearing from them until next time. If we need to take that testimony, we will.
Okay. I'm not sure. They are not available to come to the next hearing.
Oh, they're not, you said?
They are not available to come. I'm sorry, Your Honor.
Oh, I misunderstood. Well, I mean, how much did you want? Do you have a lengthy presentation with them?
No, they just agreed to appear here. Mrs. Crumby submitted a letter of affidavit that was provided, I believe, in Exhibit 4. And as you stated, some of that is hearsay if they aren't here present to back up their statement. Crumbies are here to back up the statement that they've made, and I can, if need be, make the other people would probably be willing to appear next month, but the Crumbies are not available next month.
Well, let's go ahead. I mean, since they're here and aren't available next time, let's go ahead and take their testimony. It probably won't take too long, and then if we need it, we'll have it in the record.
Okay. Thank you, Your Honor. Before I step away, I'd like to thank you for your time today.
You're welcome.
Your Honor, I also like to share that the next hearings have been set for January 6, 2026. It's a Tuesday.
Okay. Very good.
Yes. They might want you because it's your statement, so you could both come. But you can both talk because you're giving sworn testimony.
Good morning, Your Honor. Morning. Oh, okay. Here, come next to me.
Okay,
right.
we're the Crumbies. Go ahead.
Okay.
All right. Can I get your names, please?
I'm Helen Crumby.
And James Crumby.
And you, sir?
James Crumby.
James? And it's Crombie is Crumbie?
Correct.
Yes.
All right. If you would let me have you each raise your right hand for me, please. You swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
All right. You've heard what's transpired so far. Why don't you go ahead and either one of you, if you'd like to go first, just go ahead and tell me. I know you've got an affidavit here, but why don't you just go ahead and tell me what
Into the thing.
what you want to say?
Yeah, we purchased the home in 1998, and when we purchased it, there was already a gentleman, a retired postal worker, living downstairs on the first floor. He's living and sleeping there and showering there and doing whatever business he had to do. There was plumbing. And we wanted to eject him as soon as we could after we bought the house because he was a real heavy smoker, and everything was stained yellow from the cigarette smoke. So we actually evicted him about 3 or 4 months after we settled on the house. But he was living there, and I don't know for how long he was living there prior to us purchasing the property. But he'd been there for quite some time, apparently. So that's about all I can tell you.
All right, thank you, Mr. Crumby. Mr. Crumby, did you have anything you wanted to add?
I believe the people that we bought the house from, also in the owner's, what they refer to, what Carol Thomas refers to as the owner's closet, I believe she ran a little business out of there. She had a hair salon. So there was plumbing. There definitely was plumbing all through that lower level.
All right, thank you, Mr. Crumby. Does the town have any questions for either Mr. and Mrs. Crumby or both of them?
Not this time, no.
All right, well, thank you, folks, for coming in. We appreciate your time and your testimony.
You're
Okay,
welcome, Your Honor.
Thank you.
And Ms. Thomas, did you have anything else that you wanted to add? I think what we'll do here is we'll continue this until the January 6th agenda. That's will be next month, about roughly 30 days from now.
That'll be just fine. We'll be here.
All
If,
right,
if,
so-
if need be, we will be here.
All right, so we'll continue the hearing then at that date if we need to, and we can pick up where we have left off and perhaps also hear more from the floodplain manager about some of these issues that you've raised, and we'll take it from there.
May I ask?
Yeah, go ahead.
I do have some concerns about the $250 a day fine and the $250 court fee. When does that go into play, and should I be worried that I'm incurring fees and fines at this point?
You aren't incurring any fees or fines at this point. That would be part of the remedial action if you're found in violation. No, I haven't made a finding of violation yet.
Okay,
We're continuing the hearing, so if I make a finding of violation at next month's hearing or at some point after that date, there would be a compliance date established in the, as part of that ruling.
okay,
And you would have some period of time in which to bring the property into compliance to avoid incurring a daily fine. If the property was not timely brought into compliance, then that fine would start to run until compliance had been achieved. But we're not there yet. We're getting a little bit ahead of ourselves. I guess the short answer is no, you don't have to worry about it today. But that would be something that could become an issue in the future, depending on how things go.
thank you.
Thanks for coming in, Ms. Thomas, and we'll be continued on this one until January 6th, 2026.
Okay, again, I thank you for your time.
All right.
And I'll
thank
get with
you.
the floodplain manager and let you know as soon as possible.
Okay, thank you so much.
Thank you, officer. Right. I guess our next case is 290 Seminole Way.
Correct, Your Honor. Good afternoon, good morning, Your Honor. My name is Michael Hauserman, Code Compliance Manager with the Town of Fort Myers Beach. As the Code Compliance Manager, I'm responsible for the day-to-day operations of the Town of Fort Myers Beach Code Compliance Department and supervise 3 code enforcement officers. Case before you today is 2025-0828, location 290 Seminole Way. Inclusion in the record, Exhibit A contains a notice of violation, notice of hearing, affidavit of service, proof of mailing, and proof of ownership. Like to admit those into evidence at this time.
I received those documents and evidence at this time.
Initial inspection was conducted October 15, 2025. The notice of violation, notice of hearing was issued on October 20th with a compliance deadline of November 17th, 2025, with a hearing date of today, October 4th at 9 a.m. The notice of violation, notice of hearing was posted at 290 Seminole Way in Town Hall on October 20th. Certified mail and regular mail were sent on October 20th as well to the property listed at the Lee County Property Appraiser's Office, P.O. Box 35, Barcelona, Illinois 62218, and sent regular USPS mail to the location of the violations, 290 Seminole Way. Violation remaining before you today is a interior, exterior remodel, was missing some information to obtain the required permit regarding values and notice of commencement and some various other paperwork. Some further, since the violation, further documentation has been submitted to the building department and is in progress at this time. Exhibit B also contains original inspection photos and evidence of the permit in-house. And also sent to you on Exhibit C, affidavit of noncompliance. Property and records were reviewed on November 25th, 2025, and this morning, where the permit still has not been issued at this time. I believe the property owner is here to speak, if you'd like to hear from them.
All right. Why don't you come on up there?
Good morning, Your Honor. Good morning, Mr.
Good
House.
morning.
Morning.
What's your name?
Kent Lepker, L-O-E-P-K-E-R.
All right, Mr. Lepker, before you begin, do you have any questions for Officer Hausman?
No, Your Honor, he's been working with me very well, and we just want to do the right thing.
All right, let me, you want to testify? You want me to swear you in?
I don't, yes, Your Honor.
Why don't you raise your right hand then? Do you swear or affirm the testimony you'll provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, go ahead.
I submitted, as requested, from initially everything that they asked, and have been assisted because I don't do this, but I try to do the right thing. So I just recently submitted the notice of commencement, got it registered and everything at Lee County yesterday, and the owner-builder affidavit was submitted.
So you submitted an application for an after-the-fact permit to get this work properly permitted?
Yes, Your Honor.
Yeah, the permit that was in-house was just missing some required documentation, and he is in the process of providing all that.
Oh, okay. All right. So what is the town seeking, Officer Hausman, in terms of a compliance date on this?
We're willing to give them an additional 30 days to get through the permitting process, or a fine of $250 a day thereafter, and there are court costs of $250.
All right, and 30 days brings us to what? It's gonna be around, I guess it's around January 6th-ish. Do you have the exact date?
I apologize. That would be fine for me, January.
January 6th?
Yes, Your Honor.
Yeah, it gets us past the New Year holiday, so January 6th. All right. And let me go back into Mr. Luker. If we set a compliance date of January 6th, 2026, do you have any, that's what the county, the town is requesting. Do you have any response or objection to that?
No, Your Honor.
All
No,
right.
no, sir.
Okay. So what I'll do on this then is I'll receive the exhibits and evidence. I'm going to make a finding of violation as to the charges set forth in the notice, which I believe are not in dispute. The owner has established, and I think it's undisputed, that the remedial actions are underway and the permitting process is underway. And so we're going to set the compliance date to January 6, 2026. If the property is not in compliance by that date, we'll start running a $250 per day fine on January 7th and run that fine until compliance has been achieved. So, Mr. Lepre, you do want to stay on top of this and make sure it gets taken care of before that date and brought into compliance so that you don't run into to that kind of a financial penalty. I am also going to need to assess by statute the prosecutorial costs, which will be $250 for the cost of maintaining this code enforcement action. Mr. Lepre, do you have any questions?
No, sir. I'd be happy to work with the city.
And Officer Hausman, is there anything else the town needs on this one?
Nothing further, Your Honor.
All right, very good. Thank you for coming in. Mr. Lepker, you all are free to go.
Oh, I'm sorry, Your Honor.
Okay, thank
I
you.
said, thanks for coming in. You're free to go.
Oh, okay, thank you, Your Honor.
Your thing.
Thank you, city.
All right, Officer Hausman, do we have any other,
Nothing
Any
further
other
today.
business?
Nothing further today, Your Honor.
all right, so I think I've got, we continue the one case, one's in compliance, so I just need to get you out of order on this Lepker case on Seminole Way.
Correct, Your Honor.
All right. Well, thanks very much. I'll get that out to you, and seeing no other business to attend to this morning, we will be adjourned until next time. You take care.
Thank you, Your Honor.
Thank you, Your
Happy
Honor.
holidays to you.
You too.